Good afternoon, all. This is Erica Berg. I'm currently the chair of the dispute resolution section for the State Bar of Georgia. I'm really happy to see everybody here today joining us for tips and traps for litigators in arbitration. This program came out of a conversation on a listserv of many really wonderful arbitrators commenting on how litigators can improve their performance in arbitration. Today, we're very lucky to have Scott Zucker, who is the vice chair of the State Bar Dispute Resolution section, moderating this conversation. He will introduce our speakers. Scott is, as I said, the vice chair. He's a partner at the Atlanta firm of Weissman Zucker. He's been practicing law for 35 years. He's a litigator, mostly commercial and business litigation, but he is also a mediator and arbitrator with the AAA. And we're very glad that you offered to do this for me, Scott. I appreciate it. And I'm really excited to hear what everyone has to say today. So thank you so much for being here. I appreciate it. Scott, I'll turn it over to you.
Thank you, Erica. Thank you for having me and what is an esteemed group of panelists that we're going to be talking with this afternoon. With regard to arbitration from an arbitrator's perspective, we're very lucky to get arbitrators from around the country to hear from on multiple topics today. And I'm going to get started just by a quick introduction for those around the screen. Maybe wave to the group as we go through it. First, no particular order, wanted to introduce Robert Arrington, practices at Wilson Worsley in Tennessee, longstanding member of the Tennessee Academy of Mediators and Arbitrators. Mr. Arrington regularly teaches arbitration issues and serves as a neutral. We have Deborah Coleman, practices at Coleman Law in Ohio. Ms. Coleman is a fellow in the prestigious College of Commercial Arbitrators and a member of the National Academy of Distinguished Neutrals. We have Joan Kessler, a longtime veteran of JAMS from California. Dr. Kessler has a PhD in communications and experience with empirical research and statistical analysis. She's mediated and arbitrated hundreds of cases, including individual cases and class action cases. Welcome, Joan. We have Joseph Matthews, who practices at J. Matthews in Florida, an expert in both domestic and international arbitration matters. Mr. Matthews has been an arbitrator for more than 30 years. He's a chartered arbitrator and fellow of the Chartered Institute of Arbitrators and a fellow of the College of Commercial Arbitrators. We have Lawrence Newman from Baker & McKenzie in New York. Sought after neutral, Mr. Newman has served as an arbitrator in cases for the American Arbitration Association, the International Chamber of Commerce. He's a co-editor of several publications, including International Arbitration Checklists and the Leading Arbitrator's Guide to International Arbitration. And last but not least, Ralph Weber practices at Weber Advising in Wisconsin. So we've covered everywhere in the country. Mr. Weber serves as a mediator and arbitrator and has a background in trial law and is an expert in decision-making science. So welcome to all of you. Thank you for joining us. For the audience, we're gonna go through a number of different topics. I've asked each of the panelists to start us off in the conversation as I ask a question, and then have everybody chime in as they wish before we move to the next topic. So we're gonna start off, again, this is all from an arbitrator's perspective to help those litigators in the audience. What should lawyers consider when selecting an arbitrator for their case? And I'll start off with Joe Matthews.
Thank you, Scott, very much. And thank you, Erica, for inviting me and my colleagues to join you all today. Scott, I was a trial lawyer for 45 years in the plaintiff's practice. And so I tend to, and I like to compare arbitrator selection with forum and jury selection procedures because they're similar, except that arbitrator selection is conducted in much slower motion with much greater access to information. But decisions really should be approached with at least the same care given to the processes of choosing forums and choosing juries. The most significant difference from my perspective, and as former colleagues at the plaintiff's bar used to ask me, as a professional schizophrenic, which I was for 25 years, how can I help with the arbitrator selection process? And I said, well, the first thing to realize is that because the arbitrator is both the fact finder and the judge of the law, and because there is such a limited basis for review, the selection process should be approached with arguably even more important concerns and as the court analogs are. And so I start with two basic observations, and that is there are generally two methods used for selecting arbitrators. One is generally referred to as a list method, and the other is generally referred to as a party nominated, or what I came to call the yours, mine, and ours approach. There are many different hybrid combinations and multiple flavors of each of those procedures. And most of the list procedures have one major thing in common, and that is that an institution of one sort or another is likely to compile the list from which you review, strike, and rank. That is, I think, today the most common process in the US. The party nominated process is much more common internationally, although I believe from my observations that it is also common in a number of US domestic settings. But whichever process is chosen, and remember, these are chosen by the parties in their arbitration provisions for the most part, either directly or by virtue of incorporating rules of different organizations. I'm going to focus on a couple of observations, irrespective of who the appointing body may be. I think today that most advocates, and I observed a growing sense of this over my years of joint work as an advocate and as an arbitrator. Most advocates today conduct quite extensive investigations into the background, beyond just the biographical materials provided by the forum, including internet searches, including telephone calls to other lawyers and arbitrators who know and have worked with them. And over the last 25 years, I think that has not only continued, but grown significantly as arbitration has become more important in more subject areas, most notably consumer and employment areas. So let me make two basic observations about what I've seen, and they may or may not be recommendations, but they're at least observations that as advocates you'll want to consider. And my colleagues may have different observations, may have had different experiences. But number one, I have clearly observed an increasing use of pre-selection interviews or pre-screenings. Now, sometimes that's conducted by an institution, for example, within JAMS or within the AAA or within other organizations, a case manager or other professional, after meeting with the parties, may conduct a pre-screening of a large body of prospective arbitrators to obtain information. And I find that is happening a lot more, and as advocates you might want to consider that. And sometimes, increasingly for me, I both before I stopped serving as an advocate and today as an arbitrator, the number of direct pre-selection interviews that I've been a part of now has increased radically in the last 5 to 10 years. And it applies whether it is an interview prior to party nomination or by party nominated arbitrators of prospective chairs or by counsel in the same setting. And so I'm aware of that increasing, and I want all advocates to understand that that's going on. And then I'm going to end with an observation that one of the biggest problems I see saw before, and I still see when lawyers ask me for help generally in the arbitration selection process, is you really need to keep in mind that whatever process is used, and by it, whatever institution or ad hoc, your ability to select, or excuse me, to have an impact on the selection of your decision maker is always subject to a final step. And that final step is that if the parties are not able, through the processes that are utilized, to reach an agreement then an appointing authority, whether it's an institution, a court, or other, will make that decision for you. So
Joe,
thank you very much.
That was very helpful. I know that there's others that wanted to input on this point. So I'm going to open up the floor to one or two additional comments before we move on, but that was a really helpful background. Anyone else want to contribute to the question of selecting arbitrator? Deborah, let's start out with you.
Yeah, arbitration is unique in that you have the opportunity to choose an arbitrator who has expertise in the subject matter of your suit, whether we're talking about commercial law or engineering or any range of things. I think one might end up getting overly specific, but the opportunity to choose someone who already understands the context in which your dispute arises and may understand the science that is necessary to interpret your dispute is very valuable.
Larry?
There's an expression that I heard from my wife when she was a medical student regarding doctors. There are three qualities in a doctor: ability, affability, and availability. And the most important quality is availability. And I think for an arbitrator, time availability is critically important. And also diligence. Will the person selected have the time and the energy and the interest to spend the time? Because my own experience has been that sometimes arbitrators tend to coast a bit, particularly on the three-party arbitrations.
Okay. All right. I want to move on because we want to get to a pretty meaty subject. Now that everyone's selected their arbitrator with that great input from Joe, Deborah, and Larry, we want to talk about the establishment of the preliminary conference. So I'm going to turn to Dr. Kessler and ask a question in the context of, to Deborah Coleman first. I'm sorry. What are your goals as an arbitrator for a preliminary conference, Deborah?
My goal is that in the preliminary conference, we're going to plan the entire arbitration, or at least that's going to get done within short order after the preliminary conference. My goal is to work with counsel to set the template for hearing preparation and the hearing itself. And at the end of the call, we will either have agreement on the major elements, or we will have set a date, usually not more than a week or 10 days away, by which counsel will have met and conferred, agreed among themselves as to what the case management order is going to provide, and an array of proposed trial dates within the time frame that we discussed in the preliminary hearing, and then come back to me to give me a chance to go over it, to raise any questions and concerns that I have, to choose the trial date, and to deal with any issues on which they couldn't agree. So sometimes it's a two-step process. Sometimes it can all get done in that one preliminary hearing conference. A lot depends on the complexity of the matter. I think it's important for litigators to know that arbitration is far more customizable than litigation. And most arbitrators will give the parties a lot of latitude to craft their arbitration plan. But we'll also express strong opinions about what we view as more expeditious, more focused on the issues that are really contested, and taking into account our commitment to manage the case towards a fair, prompt, and efficient resolution. And as Joe mentioned, if you can't agree on the arbitrator, someone else will decide. If you can't agree on what the hearing plan is, the arbitrator will decide. The agreement to arbitration has ordinarily vested the arbitrator with that power. So The details of the scheduling order, this case management order, will obviously depend on the complexity of the case. I'm going to briefly share my screen to show you. It didn't happen. All right. In the materials, you will see a list of possible topics to be reviewed for your preliminary hearing order. I'll highlight just a few of them, but you'll want to look at that in detail. Pleadings, if you will, in arbitration can be very bare bones, and there's no standards. So sometimes people are perplexed. What are they really claiming? What are really the defenses? So we might have some discussion about a time within which more specifics will be provided about the claim or the defense. I am concerned, because I'm also a mediator as well as an arbitrator, that the parties understand what's at stake in this dispute. So I'm going to want to see a CMO include timing for the disclosure of the exact relief that is sought, and if it's damages, what the amount of damages is that is sought, and how it was computed and what was relied upon to do that computation. We're going to have a discussion about, obviously, when is the hearing, but also how is the hearing? Is it going to be in person, on papers, by video, a combination of those, depending on the nature of the proofs to be submitted? That's just some of the things that I think are pretty routinely discussed. Beyond those items, there's some things that come up in particular cases that I wanted to mention. If there's been an objection to the arbitrator's jurisdiction, that's a threshold issue, and the arbitrator is going to want that briefed as soon as possible so it can be decided in short order. And we will defer the scheduling order until it's determined that, in fact, the arbitrator does have jurisdiction of all of the claims that have been made and of the parties that have been brought to the arbitration. If there's a panel of arbitrators, we'll discuss whether the parties are willing to vest the panel chair with authority to act alone, for example, in the event of discovery disputes. We'll dig into the issue of whether there have to be non-party witnesses, because getting them in front of the arbitrator can be a more complicated process, particularly if those witnesses are located outside the state where the arbitration is venued. So we want to make sure that we've explored that and that sufficient time is allowed in the proceeding in case people have to go to court to enforce the subpoenas. In a proceeding under the AAA rules, if both sides have followed the time-honored tradition of demanding attorney's fees in the demand and in the response, the AAA rules permit the arbitrator to award attorney's fees even if it's not called for in the contract or the substantive law on which the claims are based. So if that's happened, and I'm going to look at those documents before we have the preliminary hearing conference, I'm going to ask the parties whether they really meant to do that, because I'm afraid that's one of those traps that we mentioned in the title to this program that people can readily fall into if they don't recognize the distinction between arbitration and litigation, and if they don't read the rules before they start churning out documents for the arbitrator to review. Of course, this first call is also the first introduction likely of the arbitrator, unless there's been the kind of interviews that Joe is discussing. The arbitrators hope and expect that counsel will be well informed about their case and know what information and time they will need to prepare it. And we also appreciate counsels having a reasonably cooperative relationship with each other.
A lot of information there, Deborah. Thank you. Let me look to the panelists for other inputs. Joe.
I don't know if you want to handle chat questions, but it came up and I saw there was a question about subpoenas. It's a very complicated subject, so I wouldn't go into it at this stage. But yes, there is authority for subpoenas, but it is a very clunky and complicated process. that is far beyond what we can cover today. But the arbitrators do have some authority to bring the information needed in order to resolve the dispute fairly. And then my other comment is simply the best way to keep the control of the process by counsel is to be ready and have your opponent ready to answer two questions at the preliminary hearing. How long will it take you before we can start the hearing? And once it starts, how long is it going to take to finish? And if as lawyers you can work that out with your opposing counsel, at least some arbitrators are likely to say, great, we just finished our preliminary hearing quickly. But that obviously it's in your hands as counsel. I'm done. Thanks.
I know we're going to talk about discovery in a minute as part of the preliminary conference, but Ralph, Robert, anything else on the scheduling aspect? Okay.
Yeah, I think that my recommendation to lawyers is to prepare for the preliminary conference very carefully, read the rules, read the arbitration demand and the response, talk to each other. If you're willing to talk to your learned friend, the opposing counsel, and see if you can come up with your own plan for how both parties want to handle the arbitration. I think that if Deborah Coleman is your arbitrator, she'll love you for that.
I think you stole a little of Joan's thunder there about planning in advance of the conference. So I know, Joan, you're going to talk about the discovery plan and stipulations of counsel at the preliminary conference.
Certainly. Thank you, Scott. And thanks, Erica, for inviting me to speak. One of the things that I have been delighted to learn over the past close to 20 years as a neutral and specifically as an arbitrator is how well prepared the attorneys usually are at that preliminary conference. So I don't have to have them informed that they should be prepared. Almost in everyone that I deal with is prepared. And one of the things that I usually start out with is saying, this is an expedited proceeding. We're here to move this along, and I plan on moving it along. We're going to set it as soon as the parties are ready to have the hearing, and we're going to move the hearing along when it takes place. And while I do ask, as one of my first questions at the preliminary hearing, how many days is this going to take? And the difference in one side's estimate as opposed to the other side's estimate. And then what happens as time goes on and counsel tell me they've changed their mind and they want it shortened up or lengthened or whatever. The arbitrator makes those decisions. And I have found that the attorneys usually are very respectful. And interestingly, they find my jokes far funnier when I'm an arbitrator than when I'm a mediator. And sometimes I tell the same jokes, but I think I know why. When you're making a decision, I guess you become funnier or something like that. But in any case, you should be ready before the preliminary hearing to briefly articulate what your case is about, or the defense, or whichever side you're on. And it may be that the arbitrator doesn't ask that. I always ask it, and I always say one or two sentences, just very, very briefly. And I've read the papers, and probably I already know what both sides are about, but just to do that and to explore that briefly. And then to have both sides at the arbitration, at the preliminary hearing, set down a plan for discovery. And obviously in arbitration, it's more limited than in a trial. And it's supposed to be, it's expedited. But I usually ask, how many depositions are you planning on doing? And each side will come up with this, that, and the other. And then I negotiate them down to usually one per side, or maybe a couple per side. And then if there's a problem as far as deciding on that right on the spot, as far as how the discovery will go forward, then I have them, as Deborah mentioned, take a week or a few days and come up with a discovery plan. And if they don't come up with a discovery plan, I come up with a discovery plan. So, and I tell them that as the option, which then gives them no option. So in any case, usually people will decide right at the preliminary hearing what the discovery plan is. It's interesting. Usually they'll do it on the spot. And then in addition to that, of course, you should be ready with your calendar. Have it there. And you should have your client's calendar in mind, because when the arbitrator asks you for dates, and usually the arbitrator's dates are limited, and many times the attorney's dates are limited, you need to know about your client. You don't want to come back a week later and say, oh, sorry, Ms. Arbitrator, I didn't realize my client wasn't available. No, you should have all that information, or your key witnesses know generally what their schedule is. Also, of course, are you going to have a court reporter or no court reporter? You should know that before the preliminary hearing. And you should generally have a sense, and we're going to talk in a minute about motion practice, of whether or not you think there's going to be a dispositive motion, or are you entitled to one, or whatever. And I know that's going to be talked about shortly. So, and then going forward and setting down dates of when production would take place, when, if there was going to be briefing, if the arbitrator is going to allow briefing, when that will be due, when expert witnesses, all the dates. So once again, you have to have your calendar with you, and you have to be aware of what your calendaring is. So I would say be ready, be knowledgeable, and most important, have your calendar with you and have your client's calendar.
Thank you, Joan. Any other comments from the panelists on discovery? I have a sort of a burning question. Maybe one of you could answer in sort of the fast track aspects of arbitration. Have any of you said no discovery? Ralph, you had your hand up.
Yes, well, I wanted to reinforce what Joan said about this is supposed to be an expedited proceeding. When I started practicing in the early 80s, ADR was relatively new, and clients were sold on the idea that arbitration would be a much more efficient and less costly way to go to do things. Too many arbitrations become just replicas of ordinary litigation. With when you add the arbitrator costs, it becomes even more costly for the parties. So when I talk to parties early on, I remind them that the expectation is that this is supposed to be expedited, that we're supposed to find a way to get through this efficiently so that the clients ultimately pay less for an efficient result. The second thing I wanted to add is, if I see, it always frustrated me that judges didn't control lawyers who were jerks to each other. And so early on in the preliminary conference or any time thereafter, when I sense that people revert back to what used to be called Rambo litigation, I explain that that is not persuasive to me, and ask them to commit that we will act professionally, and that throughout we're not going to do that. And so when people lose their temper, and it happens, I stop. I remind them that, remember, we're not going to do this. And it has helped dramatically improve the conduct of the hearings.
Let me just add to Ralph's comment, because I think it's very important. I've written and spoken widely on this in the past 3 years. I'm doing everything via Zoom, and mediations and arbitrations, and I still am. And I have found, and maybe it's just a function of the time, I don't know, but I have found that there's more civility than ever since everybody's on Zoom. And maybe it's because you can really see and focus in, and I don't know, but there's some reason why people are being more civil to each other. And like Ralph, I won't stand for anything less than that. I won't stand for it in a mediation either. The foul language and everything else. I know some people do allow that. I just don't think it's productive. And I think people need to be civil to each other. And I'm finding more of that recently. And I'm finding, this isn't about mediation, but I'm finding things are settling more often in these days of Zoom than ever before.
So Larry, did I see your hand up on a comment on it? Discovery?
Yes, in international arbitration, which is whereas most of my experience is, there's a tendency to be very precise in setting up schedules and of what will be permitted to be discovered or disclosed by the other side, and so-called red fern schedules and so forth. But it seems to me as an arbitrator that as far as once the parties have agreed to a schedule when the hearing will take place, it's really up to them to figure out what they want to do. If they want to take depositions, they want to do whatever they want, as long as they can get it done by the date. And if they really have a problem, they can come to the arbitrator. But I would think, I do think that they should be able to work these things out for themselves, rather than have rulings on this. I'd be interested in hearing what your experience has been.
I'm far more heavy-handed than you, Larry, because I try to keep the reins and keep it regulated, and less is more if we can, to keep it expedited and keep it moving along. And I do require that everything be locked in. Usually we can do it during the preliminary hearing. If not, then they have to come up with this discovery plan within a week, and I have to approve it. And part of approving that discovery plan is that it's not a endless series of depositions and so on and so forth, because when people are held to it, they do figure out quickly that they can do less is more, and they can cut down and cut back what they thought they'd have to do to prepare the case for hearing.
Hey, Joe, I see your hand up.
Real briefly, answer to your question, no, I have never ordered a proceeding to go forward without any discovery, but where one party is clearly and aggressively saying that discovery needs to be severely restrained, I certainly am more likely to restrain it in arbitration than any judge I ever saw would have restrained it in court. So I don't know that answers, but I didn't want your question to go unanswered.
Well, I really want to add to what Ralph said, and then move to talk to Robert about dispositive motions in a minute. I mean, I think a lot of us came into arbitration believing that it was an alternative to court litigation. It's supposed to be faster, more efficient, maybe more economical for the parties. And if, you know, the question is it sounds like many of you believe that when you are acting as an arbitrator for the benefit of the parties. As we move now to the question of how do you feel about dispositive motions, how are you handling the question of whether arbitration should be a place for arbitrators to make dispositive rulings? So Robert, tell us what you think.
All right, thank you. I think this issue ties in with what Deborah and Joan, Ralph, and Joe have already said about preparation and being aware of where you are. One of my pet peeves is that we still see a lot of lawyers who sail into arbitration apparently without having read the rules from the AAA or CPR or JAMS or whoever, and just assume that they're in court, except they have this guy or girl named an arbitrator instead of a judge, and that's not true. In arbitration, dispositive motions are generally, unless the arbitration agreement provides differently, by permission of the arbitrator. They're not automatic. That's in the AAA rules, that's in the CPR rules, that's in the American Health Law rules, and Joan can confirm or not if it's in the JAMS rules, but I think JAMS does it pretty much that way too. So segueing off what Deborah said, this is one of the things that you need to get on the table at the preliminary conference and set a deadline for asking for leave to file a dispositive motion. And Deborah has a couple of good form clauses in her handout that I commend to y'all about that. And granting a motion for leave to file a dispositive motion is not automatic. I do not grant them unless I am pretty convinced that the motion has a substantial chance of success and will likely shorten the hearing. And I have to agonize about that sometimes, because if you grant the leave to file a dispositive motion, Joe is exactly right. You have to not only pay your lawyers in arbitration, you have to pay the arbitrator too. So it makes the case more expensive if you allow a dispositive motion that the arbitrator denies because there are issues of credibility of witnesses or whatever. Now, the rules and usually what I see in arbitration agreements don't put much meat on the bones of dispositive motions. And I don't usually encourage lawyers to talk to me about the federal or state rules of civil procedure and arbitration, but dispositive motions is an exception. And I want to hear from counsel on that. What do you want? What do you think the arbitration agreement supports? Are we going to use the Georgia rules of civil procedure? Are we going to use the federal rules of civil procedure? Or what? And there can be a difference in the governing case law between a particular state and what the United States Supreme Court has said about summary judgment. And I want to hear from counsel on that subject. If they won't say anything, then I'll pick something. Usually I pick the federal Rule 56 because Rule 12 motions don't seem to be terribly helpful in arbitration because the pleadings are so bare boned. But and so I'll address this about what rules apply or what I'm going to do, either in the preliminary conference or at the very latest when I decide to grant leave to file a dispositive motion. There is a place for them. I have granted them. I have denied permission and I've denied motions more than I've granted them. But the lesson for lawyers is don't go in to, as I think Joe said this, don't go into arbitration thinking you're going to do everything you do in the United States District Court, because then arbitration will not be expeditious. It won't be cheaper. It will cost more. Learn to use the process and don't ask for a dispositive motion unless you think you have a really darn strong motion, is my advice to lawyers. Thanks.
Anybody else? Joan.
Yeah, I agree with Robert, and I think it's very rare that any arbitrator grants a full-blown summary motion. That's very unusual in my knowledge. However, there are some causes of action that might get kicked out, or sometimes a party actually withdraws them after seeing pleadings or whatever. So that does happen sometimes. And I did want to say that because I didn't mention it and Robert did, the laws that apply are and the rules that apply are very important. You need to know what the company rules are, what the rules are of the arbitration organization that you're involved with, And you need to have looked at those rules and gotten a sense of it, because the arbitrator is going to enforce those rules. And there is a discussion on my preliminary hearing time of what rules apply. Usually everybody knows what rules apply, but if they don't, we definitely set those down in the order.
Anybody else on the issue of dispositive motions? Larry, go ahead.
The CPR has its guidelines on early disposition of issues in arbitration, and it refers to various kinds of motions that might be made. Contractual covenants, prescription, limitation periods, statutes of fraud, release settlements, res judicata, collateral estoppel. But time is taken when the application to the arbitrator and the CPR guideline does say that in order to discourage premature or meritless requests for early disposition or requests made for tactical advantage or delay, the tribunal may assess against the unsuccessful applicant the costs and fees attributable to early disposition proceedings, excuse me, and in its decision should give reasons for allowing or denying assessment of costs. So that I don't know whether that's actually done, but the fear that was expressed when concerning these kinds of motions is that they're brought up for tactical reasons rather than or delay, rather than to simplify the arbitration. And oftentimes the net expenditure of time and energy is probably better spent on simply moving the case forward and going to a hearing.
Well, now that you've denied my motion for summary judgment and Robert have, I guess I have to move to the discussion about the hearing itself. You guys are tough. All right, so now we're in the hearing. Guidelines have been set, rules have been established. Let's talk about, Ralph, let's talk about how a good lawyer would present their case on direct in arbitration.
Great. Thank you very much, Scott. As you mentioned, and I've become very interested in the science of human decision-making. It grew out of my work as a trial lawyer and interviewing jurors after trials or watching jurors in mock trials and diving into how do we actually make decisions? And often reason has less to do with it than we would hope. Nobel laureate Daniel Kahneman, who's written a couple of great books on this, talks about it as the delusion of rationality. And so there are practices, though, that we can follow as trial lawyers and as arbitrators to try to overcome some of these foibles of human decision-making. And in terms of jumping back to the point on selecting an arbitrator, you know, we've all known people that about whom you'd say not always right, but never in doubt. That's not what you want as an arbitrator, and I'll say as a trial lawyer. The great Judge Learned Hand quoted Cromwell, to paraphrase him, and he said he wished inscribed above every courthouse and to start every court proceeding, and in fact every legislative session, someone would intone, beseech that ye to consider that ye may be wrong. So when I look for an arbitrator, those are the kinds of qualities: someone who will listen, who will be patient, and will acquire information and not just jump to a quick conclusion and look for information to support it, also known as confirmation bias. So direct examination, how does that apply here? Well, I guess my common theme is one of humility, and maybe it's an oxymoron to talk about humility in trial lawyers, but it is important, and it's very important in the direct exam. You know, we all have this. Let me see if I can share this. This is not what you want to do. We all think, geez, I've worked so hard to gather my case together. I don't want to waste any of my time talking about the other side's case. I want to focus on my arguments and my evidence. And if I talk about my opponent's points on direct, I'm just giving them more credibility. And isn't it better just to hope that the arbitrator will overlook my case's flaws? Well, to quote the Wizard of Oz, or to refer back to the Wizard of Oz, who said, pay no attention to the man behind the curtain, that doesn't really work. It doesn't work with juries, and it's even less likely to work with arbitrators. In many post-trial interviews, I've seen how juries pick up on facts that the trial lawyers themselves didn't appreciate. And even more so is the case with arbitrators. They see what's going on. They've seen cases like this before. And so don't bury your head in the sand and realize there are no perfect cases, and you don't have a perfect case. So instead, approach this and recognize on direct that there's going to be a cross-exam. And there are going to be facts that your opponent is going to elicit from your witness to hurt your case. And as those come out for the first time on cross, the arbitrator is going to look at you like, well, funny you didn't mention that on direct, right? So thinking about how do you persuade people and how do you persuade arbitrators, you want to come across as someone who recognizes that they don't have a perfect case. And so on direct exam, well, back up a second. Research shows actually that they find speakers more credible when they present themselves with a confident humility. You don't have to be wishy-washy about it, but you want to be confident, but you also want to present as someone who recognizes that the other side has a case. It just happens to be wrong. So arbitrators, like jurors, look for someone to guide them through the case. They want to get a just result, and they lean towards the advocate that they think is playing straight with them, so that they're not coming to the wrong outcome. So wise listeners shy away from those who convey the sense that they're never in doubt and that their case is perfect. So again, embrace the reality that the other side has some points you need to deal with. And so, of course, identify the worst facts in your case and that they're going to come up on cross-exam, and talk to them about it, talk to those issues with your witness. Don't wait for them to come up. So that's a great way to be more effective and more persuasive with the arbitrators, and increase the likelihood that they'll see the wisdom of your case. Just quickly, because we're running short on time, the other big point about direct exam is, we've been working on this case for months or often years, and we're in front of these sophisticated arbitrators, and we want to show them what great lawyers we are. So at every moment, we want the spotlight to shine on us. You feel the warmth of that spotlight on your skin, and it feels so good. On direct exam, that's not the right way to go. You want to step back in the shadows. You want the spotlight to be on your witness. And you do that not by leading questions where they're just parroting or affirming your statement of how things happen, but rather with open-ended questions that get them telling a story. So second point, step back. On cross, it's entirely different, but on direct, stay out of the spotlight and let the arbitrator focus on your witness. So that's it. Thanks.
Excellent. And I see Robert's first. Robert had his hand up first. So, and then I'll go to Deborah. Go ahead, Robert.
Okay, I was yawning, so go ahead and talk, Deborah.
But unmute yourself.
She's muted. The only thing I wanted
You're right,
to add
that was humility.
the only thing I wanted to add to it is that I put in my pre-hearing protocol that I usually use frequently that the rules of evidence do not apply, but shall be a guide. And I got that from Christy Underwood in Florida, whom Joe probably knows. And Ralph is exactly right. Some lawyers think that this is great. There's no rules of evidence. I don't have to be careful, but how much attention do you think an arbitrator is going to pay to evidence that would never ever come in court? And the answer is probably not much. So don't think that you're in fantasy land when you're in the arbitration hearing. the arbitrator pays attention to what good evidence is and what it's not. And will encourage objections even if they overrule them sometimes.
I'm going to go to Deborah and then Joan. Deborah.
Thanks, Scott. I want to step back a little from direct examination and remind those in the audience, think about who do you really need to call and what do they really need to say? I've been in many arbitrations where it's clear that people are brought in because several people say the same thing and it gets cumulative. Arbitrators don't have much patience for it. And arbitrators generally are going to be more attentive than you might expect jurors to be. So please keep in mind, who do you need to call, and just call those folks, and what do they need to say? And in that regard, think about whether you really are going to have to go through the process of getting documents identified, or whether you and your opposing counsel can agree on the admission at the outset of most of your documents so they can be used with ease or not used and simply be part of that body of evidence that the arbitrator is going to consider when the issues are fully framed and before her.
Joan?
And all I'd like to say in support of Ralph and Deborah, the arbitrator, unlike a jury where a jury might be biased or uncomfortable if certain things come in, the arbitrator's probably going to let it all in, but it goes to the weight. And, you know, I usually say right at the beginning, here's my style. It's every arbitrator's style. I'm going to let it in, but it's going to go to the weight. And when I'm writing my decision, many times I'll say, I let that in, but it had no weight. And so what Deborah's saying, cut it back, cut it down, less is more. And even if the arbitrator lets testimony in or facts in or whatever over objection, it may, it will go to the weight and it may be harmful to you.
Okay. All right. Well, Larry, hold on. I'm gonna turn it over to you for the last question because I want to save time for final thoughts. All right. Now we've done direct, and I know you've all been waiting for this. Let's talk about cross-examination. So Larry, you may want to have some comments about direct, but tell us from your perspective, Larry, what tips you can give litigators on cross-examination.
Just to finish up, I think it's important for litigators presenting witnesses not to overly prepare them, and it becomes a real serious problem when you go down the questions and the witness is supposed to remember certain keys and come up with certain phrases. That's just ineffective. The best thing to do is just prepare the witness on the facts and not on the questions. But in my experience, I put on a lot of seminars in Europe for arbitrators are advocates in civil law countries concerned about cross-examination, the fact that their education really doesn't have much in the way of trial practice. And but whoever we've had on doing mock cross-examinations, I have been struck by the fact that most of them really don't do an effective job. And the typical cross-examination in international arbitration anyway is questioning the witness on the witness statement, which is invariably used, boiling down to questions like, when you said this in your witness statement, did you really mean it? Obviously, that's the worst kind of question you could possibly ask. And as an advocate, I sit there and just relax and think there's nothing much I have to worry about, because the questionnaire is bringing up the most sensitive parts of the witness statement and expressing that he's concerned about them, informing the arbitrators of that, and then finding the witness saying, yes, I really did mean it. And not only that, there's another reason I said that. It just doesn't work. I think in preparing for cross-examination, you have to know that this is a mini jury of 3 as opposed to 6 in federal court. They're coming from different cultures. Many of them are very distrustful of the whole notion of cross-examination. It's got a bad reputation of humiliation, harassment, bullying, and you have to deal with the fact that their patience is not all that great. Their enthusiasm for cross-examination, and I think many of them oftentimes they're saying that it really is not that important. And of course, it isn't if they close their minds. But you have to preparation is critically important, of course. Knowing the tribunal. And the first question that comes up, one should address is, does this witness statement really hurt? Is there another way of dealing with what's said there rather than questioning the witness about it? One way is to do nothing and ignore it. The reality can be, and this is becoming a serious problem, is that oftentimes there's no cross-examination of a witness statement. The tribunal relies heavily on the parties to cross-examine. They don't pay much attention. They don't question what is said. It's just a witness statement is filed, put away, and unfortunately forgotten. So that's a concern, and it is a tactic that's increasingly used. Another phenomenon in international arbitration is that hearings are turned upside down. They consist of written witness statements and then a series of cross-examinations. And so cross-examination is therefore important, but must be done effectively. But there are obstacles that can be put in the way by arbitrators who will say, we're limiting the cross-examination in time, and frequently in international arbitration, the time is limited because arbitrators have plain schedules, other hearings, moving on to another city. Limitations as far as scope is concerned. Limitations as to what is said in the witness statement, not going beyond it. Whereas the most important thing for cross-examination is to find out to get the witness to tell about what they left out. What have you not talked about? And then another important limitation is what documents may you use? It's easier with an expert witness. You can use prior writings by the expert, but some arbitrators will require that all exhibits that are going to be used for impeachment purposes are disclosed in advance. Of course, that takes the
Larry, I'm going to give you one more minute because we're coming to the close. So any last points on cross, so I can close
takes the
up.
fun out of it. And bottom line is prepare. You cannot prepare too much has always been my motto.
I love that. All right, let me get any other comments on cross-examination as we move towards the closure of the program. Joe.
Very briefly, everybody, before you do a cross-examination, go back and watch Raul Julia cross-examine Dr. Kumagai in absence of malice and try to do exactly what he did. And secondly, thank you, Ralph, for saying some things that were attributed to me. I appreciate the the benefit. Thanks, Scott.
Other comments on the final part of our hearing on cross? Ralph?
Just quickly, zero in on 1, 2, or 3 points. You're not at an all you can eat buffet where you're going through the line, you just sample everything. You're more effective when you pick out 3 points and make all of them instead of trying to make 10 and only score on 8.
Okay, Joan? Yeah.
We're all saying the same thing, less is more. And it's much harder to pare it down than to do everything that you're thinking of. So do the more exerting, paring it down, less is more.
Deborah, anything else? You quiet over there. Anything on cross or the final part of the hearing?
Not specifically, but I think the conclusion is understand the difference between arbitration and litigation, the difference between the rules you're accustomed to operating under and the rules that apply to your arbitration, and use those differences to your client's advantage, whether you're talking about choosing the fact finder or planning the hearing or conducting the hearing in ways that may not be available to you in a court setting.
Robert, I see your hand up.
Remember in cross-examination that arbitrators are people too, like judges and jurors, and you don't want to beat up a witness that's sympathetic or that make the arbitration panel or the arbitrator feel sorry for her or him. Behaving like Rambo or King Kong may make you feel good, but it probably is not going to help you with the arbitrator.
You know, I like that. I think I'm going to close with the fact that, quote, arbitrators are people too. So thank you to our panel of arbitrators. I'm going to turn it back over to Erica to close, but thank you all for participating. You all are wonderful panelists and supporters of arbitration. Erica?
Thanks, Scott.
Yeah, thank you all so very, very much. There will be a small token of our appreciation headed to your mailbox soon. So we appreciate it, and the State Bar of Georgia appreciates it. This program will be recorded, or it has been recorded, and will be available on our page on the State Bar of Georgia when it comes back alive. So when we've got that functionality, and I'll send you a link so you can forward it on to those who need to know what your preferences are in arbitration. So we're very grateful to all of you, and I'm very grateful to Scott for moderating today's session. And we look forward to seeing you at our next programming. Thank you all so much.
Thank you very much.
Thanks.
This concludes today's meeting. Thank you for joining and have a great afternoon.